So hello everyone, my name is Jeff Gilmore. Thanks so much for downloading this YouTube video. As you know, we engage with many of our business partners to bring you updates, exciting challenges, new products that could impact you and your communities. So whether you're an estate manager that has downloaded this video, or a director or a trustee of a homeowners association or a body corporate, this new potential piece of legislation and code is really important for you. You will record that on the 2nd of September this year, Kusile published an article which was distributed on the ARC portal regarding the elimination of violence and harassment in the workplace. Now, you may not have thought of this before. We suggest you do think about it, because it is something that is going to be very stringently applied, as Gavin Malvena will explain to us in a minute through a series of questions. Most of you will know Gavin as a labor attorney who does the whole ambit of human resources management, labor issues with regard to all aspects of the employment of staff, the management of staff, the disciplining of staff, the dealing of conflict, as well as being always on top of, as you'll notice by the many posts that are shared by Gavin of Kusile or members of his team in relation to all new pieces of legislation that come out. But today, we're going to be spending the next 15 minutes or so talking about the code in respect of violence and harassment in our workplace. So Gav, you're very welcome. Thanks for joining us today, and I'm sure all our members, estate managers, directors and trustees are going to get great value. So thanks for giving your time today.
Good morning, Jeff. Thanks very much.
Cool. So we're going to start off with, on this issue of violence and harassment in the workplace, Gav, what is the new law in this regard?
Okay, so Jeff, as all will be aware, we've had various codes of practice regarding sexual harassment dating back to 1998, and then a second code was issued in 2005. There was a degree of confusion post 2005 as to which code applied, i.e. had the second one repealed the first one, and eventually that was indeed clarified. However, that code, or those codes, specifically dealt with sexual harassment in the workplace. And what we have now is a far broader code of good practice. It's titled the Draft Code of Good Practice on Prevention and Elimination of Violence and Harassment in the World of Work, and this is open for public comment. One can see we have a code of good practice of far broader application. It's issued by the Department of Labor and importantly issued under the Employment Equity Act. Now, a code of good practice is issued in terms of an act, in this case, obviously the Employment Equity Act. And therefore, in essence, it is a guideline document opposed to a part or a section of the act. So the act is the enabling act, and the code is in essence a guideline. However, if you don't follow the code, not that it is a breach of the act, but you'll be required to follow this guideline stringently if you as the employer have not implemented your own policies and procedures in this regard. So from that point of view, the code will be relied upon to see whether you are putting in place what's required, and ultimately whether you are liable as the employer. So it can't be seen as a mere guideline. In other words, it will be relied upon directly to see what you've done, what you haven't done, and what the extent of your liability is.
So it's very similar then if one has to take another piece of legislation like the Occupational Health and Safety Act.
If that volume's gone.
My volume's gone.
I'll have to repeat that second question. It's totally gone.
I'm now going to repeat my comment on Gavin's first, to end off his response to that first question and then move into the second question. So that's interesting, Gav. Thanks very much for that, especially for putting into perspective the importance of the code, irrelevant of under which piece of legislation it lies. The code is the code, and it's going to require us to comply. So maybe spend a little while just talking about the purpose of this proposed code. Why do we need such a code? And who will it apply to, Gavin?
So the background as to why we would have a code, and it's extremely lengthy, is there are various conventions issued by the ILO, International Labour Organization, pertaining to harassment and violence in the workplace. So it's not that we are unique in terms of a country having designed or developed this code in isolation. It is very much an international theme. And of course, we keep on seeing various examples of harassment in different forms, and they continue to feature in the media. Starting point is the anti-discrimination provisions in the Constitution, and the enabling legislation as far as the world of work is concerned is, of course, the Employment Equity Act. Now, Section 3 of that Act provides for harassment as a specific form of unfair discrimination. Keep on seeing examples, as I've said recently, in terms of a damages claim for harassment and a forced resignation. Other examples where people have been forced to strip search and things of the like. So the broader ambit of this act is probably being deemed overdue in terms of it dealing with these matters. The significant part of that is that in the Equity Act, in Section 60, it specifically provides for the liability of the employer. And it provides that the employer must take the necessary steps to eliminate any actions by an employee which contravene the Act. And that, of course, includes any form of harassment and any other forms of discrimination. But significantly, Section 60 adds that if the employee contravenes the Act, then the employer is deemed to have also contravened the Act or the relevant provision, unless the employer can prove that he did all that was reasonably practicable to avoid that transgression or the contravening of that Act. And so, as an employer, to summarize the objective or the purpose of this code, it provides you with a legal framework for the prevention and elimination of violence and harassment. Now, violence and harassment, in inverted commas, features in many places throughout this code, and it's defined as unacceptable behaviors and practices or threats thereof that aim or result in the physical, psychological, sexual, or economic harm in the workplace, including gender-based violence and harassment, and to provide a guideline to employers and employees on preventative measures and to guide HR policies in this regard so that we ensure equity, dignity, and non-discrimination in the workplace.
So that is extremely interesting. There was a statement you made which said that if there is harassment or violence between two employees, then the employer, him or herself, is as implicated for not perhaps putting enough in place to ensure that violence and harassment as defined by you is protected. So the employer is responsible for protecting harassment between one employee and another employee. Did I get that right, Gav?
Yes, so that's correct. So the deeming provision is quite obvious and quite significant. If you fail to take steps as far as is reasonably practicable, you can never guarantee anything in the workplace. But if you have no starting point and no process, no procedure, no policy, and no code of conduct in this regard, then you are liable in terms of the Act. Yeah. And of course, this Act talks to damages, not only to compensation, which we'll deal with a bit later.
Fantastic. Thanks, Gav. All right, so what are the significant elements in this code? Just help the guys understand what is significant and some of the significant elements.
All right, the starting point is, of course, that of application. It is very broad. It says that the code applies to and protects employers and employees, the obvious. Again, job applicants covered in this process. And then also to owners, to clients, to suppliers, to contractors, and others having dealings with the organization, to quote. The scope is thus very broad in its application, and it goes beyond, we can call it, a mere employment relationship between employer and employee to try and prevent all forms of harassment in the world of work. Also covers all sectors, the private and the public sector, and indeed it says it shall extend beyond the immediate workplace. So for example, if you have a work-related outing, or travel, or training, or social activity, this law will apply to those interactions equally.
Sure. Wow, so you mentioned that it covers a whole range of stakeholders, so it's not necessarily confined to the employer-employee relationship at the place of work. It's so much broader than that. And you spoke about clients. I think about service providers. You know, a service provider that's on contract, like the landscaping provider, and the staff of the landscaping provider within the workplace that is driven by the homeowners associations. Are you suggesting that there is applicability and the elements of the code would extend to those people and those stakeholders as well?
That's correct. So the origin of this is in the Equity Act itself. The statute, ignoring the codes of good practice, the additional party who's always been protected under the Employment Equity Act was and is the job applicant. However, looking at the original codes on sexual harassment, the narrower codes, they also commenced to talk about, let's call them third parties. And in here, they've built on that principle, not only in terms of the parties or third parties, but likewise the activities. It goes on then to indicate what would be broader than the traditional understanding of harassment, or sexual harassment for that matter. And it gives a very extensive list of what is seen as possible forms of harassment which are prohibited. And these include, for example, bullying in the workplace, cyberbullying, intimidation, sexual harassment, sexual gender-based violence, harassment and victimization, which is based on racial, ethnic, or social origin violence. It indeed carries on to talk about intimidation and victimization on the basis of issues like family responsibility. So a far broader approach, and indeed an analysis that would be required to be done to ensure that we have done all that is reasonably possible to prevent these type of things happening.
Sure. This is so interesting. Thanks for that, Gav. So in our environment, in the residential community industry, we have directors who are ultimately responsible and accountable for all forms of governance and best practice across all disciplines of estate management, where estate managers and staff, senior staff and junior staff, will need to be aware of this. What are some of the obligations and more specifically potential liabilities as an employer in our industry?
All those parties would be affected, and I think it's worth touching on. Non-executive would clearly feature in here as well, who may have a lesser degree of no day-to-day activity as an executive director, talking to homeowners and trustees, etc. The starting point again is that you have to be proactive and take those proactive steps to prevent violence and harassment in the world of work. Now, that phrase is defined as the world of work, meaning the working environment in which persons are in some way or another associated with work. So it is very broad. And it says the employer must take steps to ensure there are clear policies and procedures prohibiting all forms of violence and harassment in the workplace. As stated, the Equity Act renders the employer liable in that regard for compensation and damages should it be found that those steps have not.
Okay, so right now, or let's assume that the public comment process has passed. I'm assuming that we should be commenting on this. Residential estates should be making comment on this, but assuming that has gone through and it now becomes, I don't know if it's the word is promulgated or issued or whatever it is, we need to start complying in all respects of the code. And then I also want to deal with, maybe to give some thought as a next question after this, is would it apply to homeowners who are could be seen as clients to the homeowners association, and where a homeowner feels intimidated, harassed, continually picked on, which we often get accused of doing by action groups that are formed. So I'd like you to think about that. But let's talk quickly about compliance. What should employers be doing right now, Gav?
Okay, so the date you've mentioned, Jeff, it was published for comment in a draft form on the 20th of August, and it's open for 60 days for public comment. Yes, I think it is worth it. What I've noticed is that it is very lengthy and, with all due respect, seems to be rather repetitive in certain regards. And there are certain typographical errors, etc. And hopefully, in fact, it gets streamlined somewhat, because it's 50 pages of endless definitions and requirements and obligations. So hopefully it gets thrashed out and it's simplified in certain ways. To be proactive and to say, what measures do we have at the moment, and look at those, what do we need to design and implement in terms, not only in terms of policy and procedure, but the critical element of awareness and communication to the HOAs, that they are briefed in terms of what is this about, what is our written policy on this, and what have we put in place? Because indeed, looking at that broad definition of the world of work, I'm a homeowner and I have some business to do with the HOA. I'm not socializing, I'm doing work, so to say. Of course, then you fall within the ambit of the scope.
Good grief. Well, that should really be a huge wake-up call to say, let's take this code very, very seriously, and let's apply our minds properly and diligently to whatever policies and procedures we put in place. It's moved beyond, and I will deem it to say that when many people see this code, they may believe it is just another form or another extension to sexual harassment as being the only form of harassment that is key to us. You know, you speak about gender-based violence, we speak about all of these things happening in the world today, and it might even extend, well, it will, as you say, extend to us being completely aware that we are at risk in respect of our homeowners, tenants, visitors, service providers, contractors, falling within the ambit and the scope of what this code is trying to apply. So that makes it so much more critical. What are the consequences of non-compliance? This draft code is out. You're suggesting very strongly that our member estates go through it and take due note of it and put a plan in place to comply. What if we don't? What if our members don't?
Okay, so yes, that's 100% correct in identifying sexual harassment as merely one part of this code. It is far broader than that. And in fact, when I look at the main forms of violence and harassment, as it keeps talks to the concept of violence. When it talks to sexual violence and harassment, it includes, for example, topics like following, watching, pursuing, accosting, and whether that's in the physical nature or in the IT space, that carries on for pages of this intimidating, bullying, humiliating type of behavior, which is seen as unacceptable. Yeah. Because it is housed within the Employment Equity Act, that act provides for damages. And if you earn as an employee over the stated threshold of approximately 204,000 gross per annum, then the damages claims are unlimited in terms of what can be claimed. I'm talking damages per se, yes. Being sued, not only being sued in the sense of a constructive dismissal for compensation, but for damages that would be quantified in the civil sense as to your liability. To go with that, obviously one can anticipate very negative or adverse media being involved, and the reputation of that entity or state, and the views of the public in general, as to saying, we believe you have acted in a harassing or abusive manner based on whether it is gender, sex, or race, and the public says, we in general see this as unacceptable. Yes. So for want of some decent homework, that far is outweighed by the potential risks and damages that could flow. Complete non-compliance, as if it were just another law which we will deal with it if we have to. I don't think that should be the approach at all.
I agree. And I believe that we need some serious help and guidance on this issue. What can you do to help us? What should we be calling on you to help us with, both from an industry perspective, from an ARC perspective, but more importantly, from a state perspective as an employer? And I don't think there's any estate in the country, and we know there's between 5,000 and 6,000 of them, 56,000 sectional title schemes. Every one of them does have a workplace. I mean, whatever that workplace looks like, and this code's going to apply to us. What can you do to help us right now? What services do you provide in respect of this, but maybe touch on some of the other services as well, Gav, and then we'll close off.
Thanks, Jeff. The code is detailed and complicated, as I've mentioned, and somewhat repetitive. Importantly, it cross-references other acts as well, which complicates it further. We're talking Protected Disclosures Act. There's a very general Protection of Harassment Act dating back to 2011, which does not focus on the workplace, focuses on society. And we have Promotion of Equality and Prevention of Unfair Discrimination Act. So there's two other allied pieces of legislation, 2 or 3, which is specifically says must be read together. For me, the way we've approached this is to start with an analysis of existing policies. We don't want to duplicate, we don't want to confuse. However, we have to streamline and add on and edit in terms of what is our policy statement, what are our procedures in this regard, and to develop or endorse your code of conduct if there are transgressions in this. One will obviously see reference to certain rules about sexual harassment. However, people will be unaware of what this act talks to in terms of their obligations. And those need to be identified so that you know in turn what behaviors, what conduct is unacceptable and what the consequences will be for the employer and for the employee if we breach these provisions. So we've packaged it from that point of view to try and keep it practical, to workshop it in a morning session, and then to look at the current policies and draft the final set from that point.
So it should be dealt with on an estate-by-estate basis. Perhaps there are certain areas of it around workshops and seminars and things we can do. We've got chapter meetings coming up. Perhaps it's something we can look at integrating into our ARC annual conference on the 12th and 13th of May. That we can do. But every community, because it is a stakeholder code, and those groups of stakeholders are vast, would have key issues and key differences and should be dealt with on a state-by-state basis. And they can just contact you guys. Ladies that are listening to this, contact Gav directly. His details will be put up at the end of this video, and contact Gavin directly. If you miss them, then pop up a post on our website, and we'll put you in direct contact with Gav or one of his team members, who will be able to then assist you to make sure that we comply with this, because the ramifications are going to be vast. So Gav, well done. Are there any closing comments that you would like to make before we close off this session? Anything, or do you believe you've covered it all, Gav?
Perhaps one remaining question often asked, Jeff, is when will this actually be promulgated? So we've got 2 months from 20 August. Whilst I would hope it gets streamlined, I don't see the substance of this changing much at all, and it's going to become law. So it's rather pointless to say, well, let's wait and see what the final version is. It's going to be the same in substance, and to take those steps and to say what we put in place, at least by the end of this year, so that we are ready when it is promulgated.
Yeah, very, very good point. Very much like the Poppy Act that Gavin is also involved with, and other acts. The reasons why they give a due notice up front and put it out for public comment isn't only because they're delaying on when it's going to be promulgated. It's because we need that time to fully prepare. So, ARC's message and Kusile's message in this regard is start working on it now. Please contact Gav, and he can assist you in the process. Much easier doing it that way than trying to wade through it all on your own. And that goes along with other HR services and labor issues, like your conditions of employment, like your dismissals and conflict handling and dispute resolution and all of those HR issues. Gavin and his team are there to assist us, and they're valuable partners to the Association of Residential Communities. So thanks for your time, Gav, and I'm sure our members will contact you, and we'll get back to the members with regard to any workshops or seminars, or perhaps Gavin doing a presentation at our next chapter meeting as well. So thanks very much for logging in, and have a good day.
Pleasure, Jeff. Thanks very much.
Thanks, Gav.